So you describe yourself as a D and C on the DSC profile, driven to get results and obsessed with accuracy. How does that combination show up in a trial?
Well, I think in a trial, you have to look at things in the detail and in the big picture. And so if you can't get your documents into evidence, you're foregoing an important detail for your case. So you need to be detail oriented, precise, disciplined, and so on. And then you also need to step back and see the big picture. Not every detail is going to resonate with the jury or even necessarily be understood by a jury. So you have to have the big picture, consider your themes, consider what trial lawyers call the rules of primacy and recency. So the first thing you say at the start of every day, the last thing you say at the end of the day are going to be remembered by the jury more than a lot of the stuff that happens in between time. So you want to start strong, you want to end strong, and then you want to have all the details wrapped up in the meantime. And the details are important not just for the jury trial, but to make sure that you've protected the record in case you have to appeal. So that Ohio case, they took an appeal to the Ohio Appellate Court, and the court issued a 55-page opinion. But all the details were wrapped up, and so the court affirmed the verdict.
Wow. So tell me about what was that? Explain to me how that case turned. What were the key points in that case?
I think it was a David and Goliath situation. We represented a small family business that was taking on a very large law firm that had a conflict that caused it to be disqualified right before an important hearing before the International Trade Commission. And the client itself had patented this unique process for laser abrading blue jeans. And I don't know if you know familiar with the ripped look of blue jeans or the faded look of blue jeans, right? Well, they used to have those blue jeans created in third world countries by sandblasting them. And so all these third world workers were getting silicosis from the sand.
Mm-hmm.
And so our client had come up with a great laser process. And so you'd put, for example, blue jeans into this chamber and it would rotate and the laser would be applied and you'd see the jeans smoking as the pattern was being lasered into the jeans. And then you pull the jeans out and they were ready to sell. Well, everybody was infringing on that patent. They arranged some financing to pay a law firm to seek a general exclusion order from the International Trade Commission. And right before a key hearing, that law firm got disqualified. And they had told us that the conflicts had been cleared, and they weren't. And so we suffered substantial damages as a result.
So, at what point did you step into that mix? It sounds like a difficult. So you're suing the firm that was representing this group that came out with this innovative way to make blue jeans look a particular way.
Yeah, exactly. But that's true of a lot of malpractice cases, right? Some other law firm screws up the underlying case, and so then you sue the law firm for screwing it up. And you have to prove a case within the case. That's what makes legal malpractice cases so interesting, at least to me, because you have to prove the underlying case that you would have won it, and then you prove that the lawyer or law firm booted the case and caused you to lose it.